What every Social Security disability applicant with chronic pain or pain syndrome needs to know about steps 4 and 5 of the 5-step sequential evaluation. If you don't meet a listing, your entitlement to benefits are going to be determined based on the medical and vocational criteria at steps 4 and 5. At step 4, you have to show you can't go back to the lightest physically demanding job you held in the 15 years before you became disabled. And at step 5, there isn't any other work that you can do in the mythical national economy based on your age, education, skills, and your residual functional capacity. Your residual functional capacity is the key here, and that is what you can do despite your chronic pain or pain syndrome. Unfortunately, many Social Security disability applicants have medical records that just don't explain functional capacity. Can you do sedentary work, light work, medium work, or heavy work? And quite frankly, if you can't tell from your medical records, the Social Security Administration can't tell either. So they will have your medical records reviewed by a consultant who will opine that your level of functional capabilities are such that the Social Security Administration can legitimately deny your claim. It's really crucial that you have your physician complete a residual functional capacity form that will document what it is you can and cannot do. Now, the Social Security Administration doesn't tell you or your doctors about the existence and importance of these properly completed forms. These forms will explain things like how far you can walk, how long you can stand and sit at one time, and for an 8-hour day, how much and how often you can lift, stoop, squat, and bend during an 8-hour day, what problems you have with the need to alternate sitting and standing, or even to elevate your extremities, whether you have good days and bad days, how many days per month you'd miss from work, whether you have problems with concentration and pace because of your issues, whether you've got fatigue because of your syndromes that make it difficult, if not impossible, for you to concentrate and require you to take naps, and whether you have psychological problems that would interfere with your ability to work. Now, this is not an exhaustive list of the questions for our pain syndrome, IBS, or interstitial residual functional capacity form. There's also forms, by the way, for chronic fatigue, fibromyalgia, reflex sympathetic dystrophy. So there are all sorts of forms that can be used depending on the cause of your medical problems. But what's key here is that there's an explanation for what you can do physically, cognitively, and emotionally. Because if you don't have one of these forms, the odds of you getting your benefits are lower. Now, why is that important? Because I told you the other criteria are vocational criteria. The question is whether you can go back to the lightest physically demanding job you held in the 15 years before you became disabled, and whether there's other work in the national economy that you could do based on your residual functional capacity. And so if the Social Security Administration can't figure it out, and ultimately you have to file for a hearing, the judge will figure it out. The judge will determine your residual functional capacity, and there will be someone else at that hearing, a vocational evaluator. The judge is going to turn to that vocational evaluator and give a hypothetical. So, for example, the judge may say, I want you to assume this hypothetical mythical person just like the person sitting here. They can sit for 6 hours, they can stand for 6 hours, they can lift 10 pounds. Can they go back to the lightest job they held in the 15 years before they became disabled? And if the VE says yes, you lose. And if that's the end of the questioning, you lose. Now, hopefully, the judge will add something relevant to that hypothetical, like they have to take naps every 2 or 3 hours, or they have to change positions every 15 minutes, or they'll be off task 20% of the time, or they have to go to the restroom because they have to have problems with it requires them to go to the bathroom. Look, what's key here is that the next question is there other work that this person can do in the mythical national economy and view their age, education, skills, and residual functional capabilities? If the VE rattles off 3 dumb jobs that you wouldn't want to do and don't pay a living wage, you are going to lose unless the judge adds something to that hypothetical. Look, I think that it's crucial that you have an attorney who represents you at all stages of a Social Security matter, from the initial application where people make mistakes about their job description and don't get a residual functional capacity, to the request for reconsideration stage where they make the same mistakes over and over, and at the hearing stage. A hearing is a trial. Look, you don't know anything about the 5-step sequential evaluation, what's in your medical records, getting the right residual functional capacity form, telling your story to the judge in a way that they'll understand, knowing how to answer those kinds of questions properly, being able to present an argument to the judge about why you should get your Social Security disability benefits and not just because your doctor said you couldn't work, and to cross-examine that vocational evaluator. The odds of you getting your Social Security disability benefits are greater when you're represented by an experienced Social Security disability attorney like myself. So make the call, Cavey Law, 727-894-3188.